402 hearing as to searches from the defendant's iPhone 4 and 6. I have those exhibits marked, but I wanted the court to preview them to make sure it's in conformity with its ruling. Can I provide those to the court? They have been shown to the defense.
Okay, you might remind me what my ruling was with regard to...
There were several things that were discovered in the search of the defendant's phone, which included the change of identity, screenshots of McStay's phone records from the Rick Baker blog book site. I believe that was it. And then pictures.
Oh, yeah, I already ruled on that, right, as to what was admissible and what was not.
Okay. Should I just assume, absent an objection from the defense, these are in conformity, or would the court like to preview them to make sure I don't step on its ruling?
Okay, sure. I'll review them.
Okay. The other is, during an objection, Mr. McGee stated in front of the jury that Ms. Rodriguez's question was misconduct. First, the people have concerns with that being inappropriate conduct in front of the jury, as it has no bearing on their determination of the evidence. Second, because he used the word misconduct, we would ask for a formal hearing for him to establish that in fact it was actual misconduct, and ask for the court for a detailed and specific ruling as to whether or not it is.
Well, when the statement was made, I indicated what could be asked. I think it was basically the form of the question. We had a discussion outside the presence of the jury about whether or not the witness, Mr. Weitzman, could give the information that he obtained in a phone conversation with some people. I said no. Said if there was other appropriate material for a forensic accountant to review, he could review it, maybe he could base his opinion on that. Barring that, I indicated that with the offer of proof that appropriate witnesses would come in and identify those transactions as being cash advances at a casino. Rather than having to recall Mr. Weitzman, I would allow the prosecution to ask a hypothetical question that basically if those were cash advances, how would that change his charts or opinions? And the first question that was asked by Ms. Rodriguez was not in the form of a hypothetical question, which prompted the objection by the defense. I indicated she could re-ask the question using the hypothetical format, which she did. I don't think we need to do anything beyond that.
I would like to address the issue of making those comments in front of the jury. That in itself is inappropriate under the rules of professional conduct, because those determinations are not in their purview, and they are clearly designed to inflame the passions of the jury by making such statements.
Well, it is true that that is something that should be brought up outside of the presence of the jury. So that is correct.
Okay. So the court is finding no misconduct on behalf of Ms. Rodriguez as far as...
Correct.
Thank you.
Anything else?
Just so the record is clear, the objection to the testimony and hearsay statements and how it came in, it appeared based on the witness's testimony. He was testifying under Evidence Code 1523, which is a summary of records, which does not allow for the hearsay statements to come in. The arguments that an expert can rely on hearsay would be if he's testifying in 801. He offered no conclusion, which is the outside the purview of the jury. He was just summarizing totaling, so I think this is a 1523 admissibility issue. So that's the basis of our earlier.
I disagree. I think the charts were the summaries, but he had opinions that were
Classification of?
Classifying both income and expenditures, and so that did constitute an expert opinion, and additional information if certain transactions that he first indicated, he didn't know if they were a purchase or a cash transaction. If there was additional information that verified it was a cash advance, that would change that opinion. I think it was proper in that format. But I did sustain the objection that just calling someone and asking, hey, is this a cash transaction? Oh, it is, okay. That's really not overall, in my view, was not general material that expert reviewed and then came to a conclusion that was hearsay. So I sustained the objection, but allowed, based on the offer of proof, allowed the hypothetical. Okay?
Yep.
Yeah. So if I remember correctly, with regard to the iPhone materials, there were 3 areas that I indicated would be admissible.
My understanding, Your Honor, was that the court was going to allow testimony regarding the tire tracks,
The close-up photographs of the tire tracks.
the copies or screenshots of Joseph McStay's last cell phone activity, and then the change of identity, and then the Alaska leaving the U.S. borders searches.
I think just the U.S. borders, not just the, well, I guess anything relating to U.S. borders and change of identity, yes.
Yeah.
That's our recollection, but like I said, I do.
Well, I appreciate the heads up that that was coming, because if there was an objection, I would have had to review that material to recall those rulings. So I'll look at these over lunch.
Oh, it's the single one you're trying to do this one. Thank you, Your Honor.
So I reviewed the material from the phone, which I think is marked now as Exhibit 899. So, a couple of questions on it. The part that deal with the phone records,
Yes.
the first page of that has McStay family found dead, disappeared timeline, worldnews.com, and then 12-8 Joey's cell phone records posted. That's what was actually on.
That's the screenshot from the phone.
Okay. And then the other web searches show, for instance, a web search for Alaska, U.S. borders. Can you get to Canada without can you get to Alaska without going through Canada? But we don't have the actual sites, if any, that were actually visited, correct?
If I recall, and I'm trying to get assurance from Mr. Smith who investigated or looked at those, my understanding is those were searches done, but there were no websites actually visited, if I understand that right.
Correct.
So.
Okay. 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 So that's fine. Those are within, all of these are within what the court said was relevant,
Thank you.
marginally relevant. Well, then, above the 352 stand barrier.
Thank you.
Yes.
Yeah, sure. I was able to print out the records of the exhibits that were went over by Sergeant Smith during the lunch, and I started to review them. The defense is requesting a continuance. Things that I found in there are consistent with the defense's approach on this case for the cell towers, and I need more time to go through all the records to highlight and find all the issues that I saw. And I'll see issues on every record I was able to look at that are important for the defense. And based on these being produced to us or shown to us this morning before they were marked and given to us at 11:24 when the email came over, I'm going to need at least a few hours to go through them. And so I'd request that we continue cross-examination until Monday so I can finish that review.
That's fine, we can postpone the cross-examination on that witness on those issues, and come Monday we can proceed with other witnesses today.
Well, my understanding is their next witness would be Detective Bowles, or, excuse me, Agent Bowles. That was scheduled for the 25th, and we have our expert coming in. I received an email from Mr. Himes, was it Friday?
I'd have to look up, it was sometime last week.
That they were looking at, based on the change in witnesses, that they want to move him up. Our expert cannot accommodate him to come down, so he will not be available for that testimony based on flight arrangements. And the other issue I have too is I really want to address this information with Mr. Smith before Mr. Bowles testifies, because based on the defense's understanding of what we expect Agent Bowles to testify to, the testimony of Agent Smith will be contradictory. So we want to be able to highlight that before the testimony begins. So while unfortunate it is for a waste of court time, that's the best we could do with the late discovery provided to us. On a unrelated side note, the weather's getting real bad and areas are being closed down, and I think the jury might appreciate where they're traveling to, because I understand roads are being closed right now all over for snow.
All of the information contained in the exhibits used with Sergeant Smith, the three, are information that's been contained in the phone records since they've had the case in before. They are just a compilation or a summary of the data that has already existed. If it is something that is so consistent, or maybe inconsistent with the defense theory already, then they've clearly already gone through that data and are aware of the cell tower hits and are aware of the cell tower hit patterns. So to me that indicates they would be prepared. I'm not opposed to interrupting or stalling cross-examination until Monday. However, Agent Bowles is here. He's prepared to testify. The fact that their defense expert could not be accommodated should not be a concern of the scheduling for the court. As we've noted, he can watch it live online or post it on YouTube tonight. Since more than likely his testimony will go over into Monday anyways, and the convenience of their witness to be here is not importune to the ability for the people to present their case in an orderly and timely fashion.
It is not about the information in the records, which we did. It's the means of which the reliance on those records and what they're finding important is contrary to what I understand Agent Bowles will testify to, or what you can actually derive from that information is where it becomes important. So I didn't know they were going to highlight these calls. I didn't expect them to go into this area, and so I want to confirm how many contradictory information or reliance would be able to be presented on me close to 200 calls, to which I've not gone through more than 10% of them at this point. And so, I mean, it's honestly, it's necessary for the defense. If we wanted to go down this road, we would have got at least the day before. I could have done it last night and probably been prepared.
I mean, you've had all the records of all the phone calls.
I have, but I have not had this where they're trying to say this shows X, Y, and Z. And that's different, because having the records is one thing. Saying they actually show something and showing an opinion, as Sergeant Smith just testified to and summarizing a report, that's different. And that's the issue that is, when I saw it, I said, wait a minute. And I started going through what I remember from the records, and there's more that I have to go through with the details as listed on that exhibit.
He also did not render an opinion. He simply said that's what the records show as cell tower hits. He was very candid with questioning from the prosecution that he could not tell you where that phone specifically was or where the whole user of that phone specifically was at the time it was used.
No, I
Simply
understand
that
he didn't even do the location,
Sure.
directional.
He just simply summarized stuff that already exists in those phone records that everyone's had for years?
I can explain to the court ex parte what I'm seeing so the court can at least get an understanding of where I'm going, so. It would take me a minute to explain.
Well, I was gonna put a little bit before 4 o'clock today anyway. Since Bowles is here, I'd rather go ahead and start with his testimony. If we finish direct, I would not have him start cross. We go over to Monday, and if on Monday you wanted to go back to Smith first and then cross with Bowles, that I'm not agreeable with that.
I would definitely want to do Smith before Bowles on cross. My other problem is I don't want to have to rely on a third party for my expert to get to view the testimony of their expert. I understand from other people that the broadcast that they can watch live is not reliable. Actually, I don't think they're broadcasting right now because of the signal issues they're having.
Okay, well,
I just don't want to say that, well, they can still see it, they're just not here.
well, you'll have the transcript of it.
The transcript we would receive usually the next day, so we receive it Monday. And so it's hard to...
You'll be able to receive it tomorrow.
That's true. If it's available tomorrow, then we can scan it in and forward it to them, yes. That we could do if they just prepare this time.
Okay.
But it'd be the defense's preference that we do one witness at a time so that people don't able to present witnesses in order without cross to show issues between witnesses. Because that, I think, gives an unfair advantage to the people on them getting to show only their side of a witness before defense gets to cross. And that issue was raised by the late discovery of the people, so they cannot say it wasn't of their doing.
Discovery.
Just the only issues that Sergeant Smith discussed were cell tower hits at certain casinos. He didn't go through other locations. Based on the latitude and longitude sightings on the record, so I'm willing to proceed with Bowles today. If we finish direct, we'll quit. I won't have you cross. And then on Monday, if you want to cross Smith before you cross Bowles, that's fine.
Can I at least explain to the court so the court has an understanding before you have to go forward?
No. No.
Because I think the presentation or the multiple witnesses without cross is to the benefit of the people. And I think that would be a due process violation for the people to be allowed to call witnesses in between cross without our ability to cross effectively. So that'd be the defense's objection, and we would not.
All right, the objection's overruled. Okay.
You know, before we start, Mr. McGee and I have just 2 minutes. I have to, based on the court's ruling.
Sure.
Okay, thank you.